Judge Kaplan says the clerk will publish the verdict. The clerk says, as to battery, did Ms. Carroll prove that Mr. Trump raped Ms. Carroll? The answer is no. Carroll, answer no. Clerk, abused Ms. Carroll? Yes. Dollar amount, $2 million. Let's see. They're going through again. Actual malice, yes. Injured, yes. Amount $1 million. Reputation repair program, $1.7 million. So I do want to get a total here. There's also a mention of wanton disregard, yes, $20,000. So there are $3 amounts mentioned here that ends up being, looks like, $4.72 million, if my math is right. So don't quote me on that. But again, reaction, Thane.
I'm not sure I even understand that, Katrina, right? I mean, think about it. The jury is now awarding damages based on defamation that President Trump told the world that this was a lie, that he never raped this woman. It was all made up. And the jury would have to then conclude that it wasn't made up, that this actually took place and she was sexually assaulted. So the less that the jury was able to come back and say there was a battery that rose to the level of a rape, I don't understand where the damages is, because the allegation was, I never raped her.
Well, they
this
said
never happened.
But Thane, here
and so I guess they're then saying, well, it did happen, but what happened wasn't really a rape; it was something else.
Well, she has two. I mean, there are two parts of her claims. There is the battery charge, but then there's also the defamation charge, which happened at two different places. And if you look at this, as to battery, did she prove that he raped her? No. Abuse, yes. And again, you know, Ameer, could abuse be characterized along with wanton disregard and defamation in more of the defamation part of the case as opposed to any physical abuse, so to speak?
I'm a little confused as well, and I share Thane's view on this, which is the defamation had to do, as I understood it, with Donald Trump saying that E. Jean Carroll was making this all up when she said that he raped her.
Well, it sounds like, just to cut to the chase, and let's bring Sid back in here. Sid, it sounds like the former president actually did not end up well in this case.
No, I disagree. I think he won. I think he won. He doesn't care about the money.
Well, you can say that if you'd like.
Yeah.
But the news is going to show, and the discussion will be, at this point, $5 million. Tell me how you think that he won. Go ahead.
He won. Joseph Tacopina protected his record. He was up for a rape charge, liability, whatever you want to call it. He was not found liable of rape. He doesn't care about the money. Trump was signed a check today for $5 million, $10 million.
You mean
this trial was all about a rape allegation that didn't happen.
Okay, there was sexual abuse that they found.
They didn't say that. They said abuse, not sexual abuse.
That's what the report is saying.
I'll block away.
Libel of battery.
I'll take this off. I just want to make sure I'm not.
Who's talking? Okay, go ahead. Go ahead, Lydia.
So it's libel of battery, which could indicate it indicates sexual abuse, and it's saying here rewarded $2 million in damages, but the jury of 9, including 6 men and 3 women, deliberated for just under 3 hours. So that's pretty incredible. I mean, the fact that they even came up with the monetary damages in such a short amount of time.
Well, that's what surprises me. You were absolutely right, Sid. It was a quick decision, and to me, it's especially quick if you don't sit around and say, well, wait a minute, how much money does Donald Trump have? When you start assigning numbers to that.
Yeah, but I mean, I agree with what Sid said here, and you know, Jonathan, I want to get your thoughts. I mean, the fact that the answer is, did Ms. Carroll prove that Mr. Trump raped Ms. Carroll? The answer definitively is no. And to me, again, looking at that 4-letter word, actually, I'm going to ask you about this thing, specifically speaking about the fact that there was no proof of rape. The jury said no.
Katrina, I would be in the courtroom tomorrow appealing this. This to me is completely appealable. As you heard, and certainly Ameer, I think, as we usually are, in a full agreement. The burden here, it's not just a battery. A battery is illegal touching, but the battery was very clearly specified a sexual assault that constituted a rape. And that's what needed to be proven. The jury needed to be convinced more likely than not, that's the legal standard, not beyond a reasonable doubt, more likely than not that in a crowded, lavish department store in New York City, that a rape took place without any screaming, without anyone seeing it, with no police report, with no rape kit. You know, these people all watch Law and Order. They know what happens with a rape. As Lydia mentioned, you don't even remember the date. You don't even know what month it is. This is not the kind of case you could bring. No prosecutor would ever bring this as a rape case, which is why I always thought the burden here is very high, that the jury would have to walk out of here and say, we believe, even though the evidence was flimsy and would not have been used in a criminal courtroom, we believe she was raped on such and such a date, although we don't know exactly what date it is because she never told us that date. But if they're coming back and saying this is an unspecified battery and they're not using the word sexual assault, I don't see where the defamation is.
Agreed.
I don't see how you can find defamation unless you can find rape.
I think. Agreed. And Tacopina's going to be appealing this thing tomorrow. But again, don't worry about the money, whether it's $4 or $5 million. That means nothing to Trump. He did not want to be labeled a rapist. He is not a rapist. They came back with no. So trust me when I tell you this was a major win for Donald Trump today. They will appeal it. And I guarantee you when they appeal, some of these damages and that abuse charge will go away too. But the main thing was rape, yes or no, came back no. That's a win for President Trump.
Well, as I'm reading this, there is liability for sexually abusing Agent Carroll.
And that's what they're saying, the abuse. They're saying rape, no, abuse, yes. And interesting, I want to tell you even a little bit how we're seeing this spun as we knew we would. Maybe it's not spun. Ameer, you tell me what you think. This is from the New York Times. They're saying that the Manhattan jury found the former president, liable for the sexual abuse of
Let's bring in
Eugene Carroll.
Alan Dershowitz, constitutional lawyer. Alan, you've been watching this develop. Your thoughts here?
Well, it's a confusing verdict. On the other hand, the jury said that there was no rape, and that's what Donald Trump said. And so how can there be a finding of no rape and yet a finding of defamation with malice? If there was no rape and Donald Trump honestly believed there was no rape, then it seems to me the defamation case is out. And I don't know what the jury meant when it said there was no rape, but there was sexual abuse. It would suggest that the jury believed that she was lying.
Well, let me ask you this, Alan. Is there a difference in the legal charge of rape versus sexual abuse? Because this jury may be using that as an easy way out, if for lack of a better term. So because they could not prove that there was a rape. So as a more general allegation, are they using this to say, well, we think something went on. We just can't say that it was as explicit or as clear as rape?
Yeah, that may be what the jury was thinking. But legally, it's going to be very hard to justify a defamation verdict in the face of a conclusion that not even by a preponderance of the evidence, 51%, the jury believed that he raped her. Remember, she said he raped her. So the jury effectively found her to be lying. She can't just be mistaken about that. She was raped. Wasn't raped. The jury found she wasn't raped. That's what happens when you have a 25-year-old case or an older case. That's why this case should be reversed on appeal based on the statute of limitations. I don't think it's constitutional under the Seventh Amendment to extend the statute of limitations and allow a jury to decide on a case which is so old when the statute of limitations had already expired by the time it was expanded. So I think there's going to be a very interesting appeal here. And if his name was not Donald Trump, he'd win the appeal. Because his name is Donald Trump and this is New York, there's no predicting how the case will come out.
On what grounds? Give us two grounds that you would appeal this on.
Oh, the first ground would be the statute of limitations, that you can't change the statute of limitations, even in a civil case. Once the statute of limitations has been over, once it's over, you can't expand the statute of limitations. Second, I would appeal on the ground that the tape, where he talked about how women allow him to touch their private parts, was admissible. That was so much more prejudicial than it was probative. So I think there's a very, very strong appeal here. And I think if his name weren't Donald Trump, he'd win the appeal. But the statute of limitations is a big deal. There's no good reason in history and logic to allow a case like this, a civil case, to be tried 25 years later. How does a defendant disprove it? Look, I think myself, Trump, I think, made a mistake by not appearing in the courtroom. I think it showed disrespect for the jury that he didn't look them in the eye. Whether he testified or not, I think he should have been in the courtroom. for at least part of the trial. But the jury may very well have looked at the evidence and concluded they weren't sure. So they came up with a compromise split verdict, sexual abuse, but no rape. It's a strange verdict in light of her clear testimony that she was raped.
Alan, hang on a second.
Alan, I just got a text from Joe Tacopina. Alan, by the way, good to see you, my friend. And I said to him, I said, Joe, you won. F the money. Rape, no. Abuse, yes. Defamation case, huh? He said, yes. Crazy. She said rape, but they said no rape and sexual abuse. And he seems to think, like I do, that the president won today. And all of Alan's points are correct. If it was not Trump, it almost feels like you had a New York judge, liberal, a New York jury, liberal, and they weren't going to let Donald Trump just walk. So they knew he didn't rape her, but we can't just let him walk. So let's say abuse and throw a bunch of millions of dollars out there. That's what this smells like to me.
Because they wanted to find him guilty in the court of public opinion. And you have the Washington Post, their big headline, jury in civil trial finds that Trump sexually abused and defamed E. Jean Carroll, awards $5 million in damages, and not Trump found not guilty, or not liable, excuse me, of rape, of sexual assault. So that's where you see the dichotomy there. And this is what they wanted. They achieved what they wanted. They feel like they won, but in reality, to your point, Sid, he won because they found him not liable in the case of rape because she could not prove something that she doesn't even know the date of.
As I think all cases when it comes to Donald Trump,